Hey, what's up, everybody? Welcome in. It's Tuesday night to Let's Talk Live here on the LTL Media channel. I hope everybody is having a fantastic day so far. We're going to continue our theme this evening in the Looking Back series. And I thought we would go back to, let's see, geesh, what month was that? Gosh, my dates are all messed up. In January, when we heard the first of the federal probe in Karen Read's case. And we had 8 letters that were put out back and forth between Josh Levy and DA Michael Morsey's office. And I actually got to break those letters on my channel. So I was very thankful for the source that gave those to me. It was a pretty interesting live. And we'll go back and hear Karen Read's hearing about that in a really powerful. I'm sorry, I'm a little off tonight. I'm going to be honest. I'm a little off tonight. A very powerful statement from David Unetti got put on the record, which was great. And to the fact of the genie cannot be put back in the bottle. I always love that saying from Unetti. So welcome in, everybody. Welcome in. We'll get going here. My my social life has changed quite a bit. So my schedule is wide open, and I'll be doing probably a lot more lives and digging into some more cases, but still continuing the theme of Karen Read on this channel until her name is free and clear. So yeah, let's get into that. We had another response from Karen's team today. We'll talk a little bit about that and maybe a little bit of a bonus feature here at the end of the show. I saw that the Canton Select Board meeting, they're doing that now via Zoom. So they are afraid to face the public. They are afraid to face public comments and concerns in their town. Complete cowards, silencing the public from concerns. And we have a big concern. A Boston police officer was murdered at 34 Fairview, and they don't want to hear about it. They don't want to speak on that, and the framing of Karen Read. They don't want to hear, and they don't want to answer for that. So I believe these now are going to be via Zoom. They're complete cowards, and continue to fight, Canton residents. That's all I have to say. Continue to fight. So let's do this. Let's pull up this article here. So I know that you probably all, if you're in the justice group, you probably read the response today. We'll read this from Boston.com. And here we go. Karen Read's lawyers are doubling down on their push to dismiss 2 charges. Judge Beverly Cano declared a mistrial with, quote, no warning to or solicitation of objections from the parties, Read's lawyers allege in a new filing. Karen Read's lawyers say they had no opportunity to weigh in before Judge Bevs declared a mistrial in the Mansfield woman's murder case earlier this month, doubling down on their push to toss 2 of the 3 charges against Read. The record reflects, quote, the record reflects no discussion of any such alternatives, including, importantly, inquiry regarding whether the jury had reached an impasse on all, as contrasted to just some of the counts, the defense wrote in a Tuesday court filing. The defense filed a motion last week asking Judge Bev to dismiss the charge of second-degree murder and leaving the fatal scene of an accident. They alleged 4 deliberating jurors have confirmed the jury internally agreed to acquit Read on both counts, reaching an impasse only on the charge of manslaughter while operating the motor vehicle under the influence, which I'm completely confused about this. Because if there has been no accident at that scene, how can you have an impasse on a charge of manslaughter while operating under the influence? It makes no sense to me. Archer came in and proved there was no accident. There was no accident. All right, let me just pull this up really quick and we'll get the ball rolling here. 25% of all donations tonight will go back and get kicked back to Karen Reed's defense. So Mag in Florida, thank you so much for the $10. Says, love the early motion review, taking notes. Literally, thank you so much for the $10. I appreciate that. Patricia, thank you for the $5. Says, thank you for the reposting these. I'm enjoying the refresher before the 22nd. I have a feeling that Monday will be filled with fireworks. I do too, and I will be down there on the 22nd supporting. I'm getting more into my rhythm now that the show has started. Feeling a little better now. I had a lot on my head before I came live tonight. So as you can see, I was a little bit off. Let's see. Ren, thank you so much. $20. I'm so sorry you're going through a tough time. Just know that you always have us. Thank you for fighting so hard for Karen and Free Karen Reed. Hey, listen, it happens in life. You know, things change, situations change, and we just have to kind of keep, pushing forward and filling our time with things. And my whole thing is when situations change, I dive into work, and I have plenty of work to do in here. So I'm going to be reorganizing the studio a little bit. I will be getting some lighting all tuned in. And so when we start having live guests back in here again, the camera will be set, the lighting will be set. All I need to do, turn it on and go. So, I'll just keep myself busy with work. That's all we can do, right? Okay, so let's see. Prosecutors allege Reed, 44, drunkenly intentionally backed her SUV into her boyfriend, Boston police officer John O'Keefe, outside a home in Canton in January of 2022. Reed's lawyers maintained that she was framed, arguing that O'Keefe's entered the home and fatally beaten before his body is planted on the front lawn. And as you remember, we watched that Nightline interview yesterday, and Karen said, look, I watched John go inside 34 Fairview, and then I got aggravated and I left. Because he wasn't coming out. White Blue Phoenix, thank you so much. $3. I don't even know if I have a moderator in here tonight. Any of my mods in here? I don't think so. I'm going to have to keep total of this. So let's do this. I got 10, 5, 20, and 3. Okay, we're at $38. $38. Hey, there's some of my mods. Hello, Rogue. Hello. Thank you. Am I at 36? 36. Okay. All right, let's keep moving on here. Let's see. Judge Bev declared a mistrial after jurors said that they found themselves starkly divided. However, Reed's lawyers said since they heard from 4 jurors, 2 directly and 2 indirectly, that they deadlocked only extent to the OUI manslaughter charge. Responding to the defense team motion, prosecutors alleged, Reed's lawyers built their argument upon hearsay, conjecture, and legally inappropriate resilience as to the substance of the jury's deliberations. Ooh. In Tuesday's filing, Reed's lawyers continued that the prosecution's opposition is based on several clear fallacies. Let's just pull this up. $2. Thank you. $2. Lady Law. Thank you. I appreciate that. You have your lawyer look down. You have your new avatar and you get your lawyer look down. Good luck in law school. Commonwealth opposition is perhaps the most notable for what does not dispute that according to the information from 4 deliberating jurors, the jury had reached a unanimous decision that Miss Reed was not guilty on 2 of the 3 charges pending her case, namely counts 1 and 3, and the defense wrote. If you haven't seen already, I had Mark Betterow on here a couple days ago. You need to go back and watch that live, and he kind of clears a lot of this stuff up for us. And again, still very confusing. Very confusing. Reed's lawyers also pointed out that Judge Bev declared a mistrial with no warnings to or solicitation of objections from their parties. Let's just do this real quick. Hey, Audrey, thank you so much. $5 says, loving the recap. Greatly appreciate the refresher. Looking forward to watching you cover more cases. Thank you. I got one that I need to go back into. And that's the Chelsea Grim case. That one's been bugging me. I need to get back there. I'm actually getting ready to go like knock on the parents' door and say, where's your daughter? Why did you not go out to Arizona to find her in the desert? Why did you stay home? A lot of issues with that case. The defense requested the Reed's jurors a Tui Rodriguez instruction or dynamite charge in hopes of breaking the deadlock. Did not, of course, reflect an impact concession that the jury was deadlocked on all counts. Basically, when the judge sent them back, said you need to go back and deliberate more. The defense to any position regarding whether the court should, I'm going to screw this one up. Suaponte, I think that might be right, declare a mistrial. Reed's lawyers argued. Prosecutors to say intend to retry the case against Reed, who is due back in court in a status conference on July 22nd. And they obviously have the response here. So if you all want to read that, I will drop the link here in the chat, and you can go out and read that after this live if you want to do that. All right, let me get a sip of water here, and then we will continue. All right, let's get into. Oh, I know what I want to talk about. So apparently, there has been a apology from Vinnie Politan, not the producer, but Vinnie Politan himself. Turtle Boy actually tweeted out earlier today, and I will kind of involves me here. Well, it actually does involve me because this was the night that I was supposed to go on Court TV. And apparently, Vinnie Politan reached out to, or Vinnie Politan's producer reached out to Turtle Boy. So I would like an apology. I wrote them and I never got an apology. I wrote her and I never got an apology. It says Vinnie Politan's producer has apologized for inviting Kate Peter on Vinnie Politan's show and says she will not be invited on again. She was unaware of Miss Peters' documented history of CA in her criminal record. You can see here, it says, hi, Marina. Last week you had on a woman named Kate Peter on as a guest with Vinnie and Julie Grant. My mother died 2 weeks ago, and this is what Kate Peter posted about her. Kate is also lost 2 of her children due to years of neglect and abuse. Were you aware that you invited her onto the show and gave her a national platform? Do you intend to invite her again? And then Marina wrote to Turtle Boy back and said, no, I was not aware of the apologies. No, I was not aware. Apologies. No, I do not intend on inviting her again. And then I actually tweeted at TB. Let me go back. I'll show this. I wrote to TB. Said, Dr. Turtle Boy, thanks for updating us on the Kate Peter Vinnie Politan situation. I was invited along with Mazzamini on the show that night as a pro Karen Reed supporter, but ended up completely pissed off because the producer misled me in a brief interview off air, brief interview, off-air interview, and then shared my personal information with everybody on the panel in a mass email. I don't hold Vinnie responsible. Probably isn't aware of the behind-the-scenes issues, and I accept his apology. So I protested the show and chose not to interact with the Food Stamp 5 that night. Here's my response to Court TV and the producer that morning. I wasn't happy. Still no response or apology. So I wrote, good morning, Marina. I appreciate the opportunity to participate in the Court TV segment last night. However, I was expecting you to engage with supporters of pro Karen Reed, which was not made clear during your vetting process. You requested basic information such as my full name, phone number, and purpose in the Free Karen Reed movement, and I disclosed that I'm a local content creator who has been covering the case for the past 10 months. Following our phone call, you mentioned sending instructions via email for joining the program via Skype. At no point did you mention that my personal information would be shared with other panelists via email to confirm their appearance. My full name and email address were shared with Kate Peter, a guest known for harassing Free Karen Reed supporters in the vilest way possible. This concern prompted my decision not to participate in your program last night. In the future, I recommend being transparent with your guests about how your personal information will be handled and ensure that the best practices are in place to protect personal data from potential misuse by others. Now, obviously, here you can see sincerely, Brian, LTL Media. So wanted to update everybody on that situation. All right, let's get into the hearing. Back this up. I'm going to throw this up on the big screen up above me. Unfortunately, when this live feed came in, it cut a little bit of the beginning off, but we're going to hear about the federal letters. Then we'll hear the back and forth about Gretchen Voss. And here we go. Let's do it.
Letters hidden from the public is warranted. The court must first consider the content of those letters. And in order for me to be able to argue against this motion for a protective order, I must.
So just so it's clear, I have not seen those letters.
Okay. I still, Your Honor, I must discuss the content of those letters to some degree and argue to this court why a protective order makes no sense in this case. And with your permission, I'd like to divide my argument on this issue into two parts. First, I will argue to the court that the Commonwealth has not met the legal standard necessary for the issuance of a protective order. And second, I will argue to the court that a protective order will accomplish nothing in this case because the content.
All right, so which part do you need to reference the letters? Because I'm going to need to read them before you reference them.
So with regard to the first part, which is that the Commonwealth has not met the legal standard, the only way to discuss whether they've met the legal standard is to know what the letters are. And just
right. So I need them. I don't have them, and so you would be arguing the content of the letters in the first part. All right. How about the second part of your argument? Would you be arguing them as well? Nobody provided them to me.
Well, this is the Commonwealth's motion, Your Honor.
Yeah, and your opposition, and I don't have from anyone. So how about the second part of your argument, Mr. Yannetti?
Well, it does touch on that, Judge. You know, the Commonwealth has revealed some of the contents of some of the letters, but I need to point out what they haven't revealed. You know, and just so it's clear, I'm not going to be quoting the letters at length. I'm going to be talking about the subject matter of the letters. In my view, I don't know that the court needs to read the letters first, but I'll leave that to Your Honor.
All right, but you said you're going to reference them, and the whole motion concerns those letters. Do you have them, Mr. Lally? Do you have them with you?
Yes, Your Honor.
If you're just going to, in general terms, just give me a couple of minutes now to just look through them, Mr. Yannetti.
That's fine, Your Honor.
Anybody wants to know the date? January 18th, 2024. It's the federal letters. The letters are about the federal investigation that the FBI was investigating the investigation in the Karen Read case. I forget why this was on Zoom. I know Jackson couldn't be there. This is so painful. Just wait. Just wait while I read them.
So, Ms. Giannetti, so far there's one letter that I'm going to need more time on. It's a letter dated May 18th, 2023. The others so far, I'm prepared to let you argue in general terms.
With regard to that May 18th letter, Your Honor, that is not one that I will be quoting.
Okay, that's why I brought it up.
Right.
Okay, so
why I responded.
you also not going to reference the response to that letter?
You're
June
right,
1st?
Rissa.
Correct. Yes. Yeah, those deal with the Office of Professional Responsibility. That was
Okay, I just have two more to just quickly take a look at.
Sure.
Oh, look at that. No filter, checking in. Look at this. How are you, Brian? You inspired me to sign up for college. Wow. Starting this fall in a Bachelor's of Science Legal Studies. I know you struggled. I'm 56, so I may be in the same boat. Well, you can get through it. Believe me. I'm probably more disciplined in life now than in my earlier days.
All right, so I'd also like some time to take a look at the June 21st and August 3rd letters. Were you planning on referencing them?
I'm going to reference them in terms of a subject matter, but not the details.
So the letter dated August 3rd, 2023. You have that in front of you, Mr. Yannetti?
Do, Your Honor.
All right, so the second paragraph, the second full paragraph, I'm not going to allow you to reference that right now.
Yeah, I just noticed that.
Your Honor, if I may, the letter may be visible on the Zoom screen.
I've got the,
Just when you're holding it, you can see
see
it.
the light can see through it? Because I've got the print facing me.
You could see a portion of the print, that's all, just from the
Okay.
angle.
All right, thank you. All right, so with those parameters, Ms. Giannetti, I will let you reference the subject matter of the others.
Okay, that's fine, Your Honor. So in terms of the two parts of my argument, I will first argue that the Commonwealth has not met the legal standard that is necessary for the issuance of a protective order. The second part, I will argue to the court that a protective order will accomplish nothing in this case because the contents of those letters will be revealed in full during oral argument before the public on the motion for sanctions that we filed immediately after our last court appearance. So first, Your Honor, I urge this court to deny the Commonwealth's motion for a protective order because they have not met the necessary legal standards.
So essentially what's going on here, the Commonwealth knows about the letters. The DA's office knows about the letters. They put in a motion to stop it. And now Yannetti's essentially arguing it. And you're going to hear that famous quote come out here pretty soon, which is so great.
Standard. In their motion, the Commonwealth cited Mass General Laws, Chapter 4 and 27D, which stands for the proposition that interagency memoranda or letters relating to policy positions being developed by an agency should not be considered public records. An agency's discussion of policy positions is akin to an attorney's discussion of trial strategy. It's not work, it's work product, it's not discoverable, and it's not a public record. But that is not what we have here. The 8 letters that have been provided do not discuss at all policy positions being developed by any agency. To the contrary, these letters fall into 3 categories. Category 1 are 3 letters consisting of a back and forth between the Norfolk County District Attorney's Office and the U.S. Attorney's Office for the District of Massachusetts regarding whether the U.S. Attorney would release any information to the DA about their investigation. Category 2 are 4 letters back and forth between the Norfolk DA and other agencies, wherein the Norfolk DA is complaining about the fact that they're being investigated and asking for the U.S. Attorney to be taken off that federal investigation. And finally, category 3 is 1 letter from DA Morrissey to the new special agent in charge of the FBI, asking him to have his agents speak to the state police who are under DA Morrissey's command. To be clear, there is no confidential grand jury information in those letters. There are no records, orders, and subpoenas relating to any grand jury that should be kept under seal.
Hey, Kelly, how are you?
There are no policy positions being developed or discussed. There is nothing in those motions that's the proper subject of a protective order. And I suspect that is why the U.S. Attorney has no objection to those letters being revealed to the public. That should end this court's inquiry. The Commonwealth has not met the legal standard necessary for the issuance of a protective order, and this issue should be put to bed. The letters are not the proper subject of a protective order. They should be unsealed forthwith. But assume for a moment that this court decided otherwise and issued the protective order sought by the Commonwealth. I ask this
Here it
court,
comes.
what good would that do? How effective would that be? The answer is it would not be effective at all. And in many ways, it would be meaningless. I say that, Your Honor, with no disrespect intended. I say that because that's the reality of this situation. Immediately after our last court appearance, as I promised when I last addressed this court, we filed a motion for sanctions against District Attorney Morrissey, including a request that his office be disqualified from continuing to prosecute this case. I expect that motion will be heard on our next court date.
Kurt.
And I ask this court to consider what that hearing will look like. That hearing will prominently feature the contents of all of the 8 letters that are at issue here today. The specific content of those letters is one of the grounds that gave rise to our motion for sanctions in the first place. In fact, our motion for sanctions liberally quotes from those letters. And I assume that that is the reason that our motion for sanctions is currently impounded by this court as well. But it is clear from those letters that District Attorney Morrissey is well aware that he's the target of a federal investigation as a result of his conduct in this case. Those letters prove that he knew that even before the U.S. Attorney ever confirmed that there even was an investigation. And Your Honor, on that score, something very important has come to light just yesterday that directly bears on this issue. The Norfolk.
This is insane. Okay, so what we're watching here is a hearing back on January 18th, 2024, regarding the federal investigation in the Karen Reed case and the investigation into DA Michael Morrissey's office. So if you're all just coming in, I've been kind of doing this looking back series to take us up to the 22nd, because a lot of people that came into this case only really watched it from the trial. They haven't heard any of the pretrial hearings. And what I'm trying to do here is establish and make you all understand how much evidence and discovery was left out in this case. We'll continue here. I'm going to back up just a little bit because this part is actually very, very important. And David Yannetti shines here. And you're going to get that famous quote here pretty soon. The genie cannot be put back in the bottle.
Of his conduct in this case. Those letters prove that he knew that, even before the U.S. attorney ever confirmed that there even was an investigation. And Your Honor, on that score,
Here we go.
something very important has come to light just yesterday that directly bears on this issue. The Norfolk DA's office and the Karen Reed defense team participated in a conference call yesterday with a representative from the U.S. Attorney's Office. The U.S. Attorney confirmed during that conference call, confirmed for both parties, that not only has there been a federal investigation of this case,
Still going.
but it is ongoing.
Whew.
It's not over. It continues. The DA had this confirmed for them just yesterday, right from the horse's mouth. That means, Your Honor, that District Attorney Morrissey and his office are targets of a federal investigation. And please consider what that means for the upcoming hearing on our motion for sanctions. The anticipated nature.
This case should have been dismissed now. After what Yannetti says here, this case should have been ultimately dismissed. Ultimately dismissed. How did we get to trial after all of this information came out? It is absolutely insane.
Of that hearing bears directly on the ruling that this court will make today on the Commonwealth's motion for a protective order to keep the 8 letters impounded. We have the 8 letters. We've seen them. We've read them. We are using them. The genie cannot be put back in the bottle. Those letters are powerful evidence that we will use to publicly support our motion for sanctions. My client is entitled under the Constitution and the Massachusetts Declaration of Rights to present as effective a defense as she can to these false charges. She's entitled to lawyers who will zealously represent her within the bounds of the law. She is entitled, in short, to have the contents of those letters made plain to this court, both in writing and during public oral argument on our motion for sanctions. And that argument will happen in public, whether this court issues a protective order or not. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. But the Commonwealth wants to keep the remainder of the letters hidden because those letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. So, Your Honor, because the Commonwealth has not met the necessary legal standard for a protective order, and because a protective order would be effectively meaningless here in any case, this court should deny the Commonwealth's motion.
All right. Is there a response from the Commonwealth or no?
No, Your Honor.
Okay. All right. So I'll take this under advisement. I do need copies of these letters. So if Mr. McDermott can make copies and then hand them back to the Commonwealth. All right. So the second motion is the Commonwealth.
Just move it along. All right. Well, we'll just take it under advisement. I mean, did you not hear what he just said? Did you not understand what is written in those letters? Federal investigation into the investigation in Karen Reed's case, a federal investigation in the DA Michael Morrissey's office. Okay, well, we'll just move it along. What's the second motion that the Commonwealth put out there? She doesn't care.
Motion for
Pissed.
Rule 17 for records from Boston Magazine. And I understand there's counsel here from Boston Magazine.
So glib about this guy.
If you'd come forward, sir.
Magazine. Oh, I love
Hi.
him.
You can stand at the podium or council table, wherever you're comfortable. In a minute, I'm going to ask you your name and I'm going to hear from you, but I do just want to state that I appreciate that today I did receive a response from Boston Magazine. I received there's a memorandum, there's a limited opposition, there's affidavit, there's a memo. I found all of this helpful. I did have the opportunity to read it a short time before the hearing. but I do appreciate the response, and more importantly, I appreciate you being here. So could you tell me your name, please, sir?
My name is Robert Birchie. I'm from the firm of Claris Law.
Could you spell your last name, please?
Last name is B like boy, E-R-T-S-C-H-E.
Okay. All right. Could
And
you
I'm
tell?
representing MetroCorp, doing business as Boston Magazine, and also the reporter Gretchen Voss.
All right. So there is the Commonwealth filed a Rule 17 motion. You, as the third party or the record holder, have a right to be heard. So I'll hear you.
Thank you, Your Honor. There are really three documents at issue. Two recorded interviews, one 4 hours long, another one 2 hours long, that are largely, almost entirely, on the record, were interviews with Ms. Reed in the presence of her counsel.
Okay, you say almost entirely on the record. Could you explain that, please?
I'm sorry. There are a few interjections by counsel, and there are also a few areas where counsel asked, or Ms. Reed asked, that certain information be kept off the record.
Okay.
So if those were to be produced, we would ask for the opportunity to redact those.
Okay, I understand that. What's the third or the second category, the third record?
The third is a interview with Karen Reed alone at her home between Gretchen Voss and Karen Reed that was not recorded, for which there are handwritten notes. And that interview is entirely off the record, subject to the parties agreeing to put anything on the record afterwards if they wanted to, but they did not. And no statements of Ms. Reed from that interview appear in the article.
Okay.
There's also a fourth category, Your Honor, that just I became aware of last night, which is that there are a limited number of voicemails and texts between the reporter and Ms. Reed that were also considered to be off the record unless otherwise agreed.
Have those been maintained?
They have been maintained.
All right, thank you.
The argument that I'd like to make, Your Honor, really has three parts. First, that the Commonwealth's request is unreasonable under Rule 17A2,
Okay.
because it really is just a fishing expedition. The second is that the documents in question are privileged under the common law privilege that permits a reporter under certain circumstances not to turn over unpublished notes and outtakes, and that's especially so if they're confidential. We are not, to be clear, opposing disclosure of those two interview audio tapes.
Okay.
Counsel was present, subject just to the redactions that I previously mentioned. And the third point I want to make is that this case really differs from many others dealing with the reporter's privilege due to the degree of harassment that this reporter has already experienced due to her objective coverage of this case.
Can you tell me about that?
I'd be happy to, Your Honor, and she discusses it in her affidavit as well. She has received emails, she has received voicemails, she has received threats to herself and to her children. She has received inappropriate, shall we say, texts with
John, I almost said Joe. John, thank you so much for the 5 gifted memberships. Let's add $25 to the total. We're going to try to at least get to $50 tonight to kick back. All right, let's keep playing here.
Photographs that have been altered.
Have these been to her private accounts or her professional?
To her private accounts, I believe, yes.
Okay.
And and she says, that these are, she's never experienced in her 25 years of reporting anything like this before. So if Your Honor is all right, I'd like to proceed to the Rule 17A2 argument.
Yes, please.
Yeah, this is the attorney that represents Boston Magazine, and that was the big controversy as far as the off-the-record conversations and bringing that into the trial. That's essentially what they're arguing here.
Rule 17A2, as Your Honor well knows, is not supposed to be a discovery tool. It's supposed to be a tool for bringing materials before the court prior to trial for the ease of trial administration. Here, the Commonwealth already has a lot they've got a long, detailed article setting out, among other things, many statements of the defendant about the facts of this case. And the Commonwealth has said that it plans to introduce those statements and records at trial. But their argument for more is simply that the article is such a gold mine, there must be more. And that's unlikely, first of all. The article set out the positions of both sides in a very comprehensive and balanced way. You can be sure that if Karen Read had confessed in her interview with Gretchen Voss, that would have made it into the article. This is a fishing expedition because, as this court has already noted in this case, Rule 17 is not supposed to permit a general fishing expedition for evidence not yet obtained. And the extra that the Commonwealth asserts might be found really isn't very applicable. They talk about nonverbal conduct. Well, they're not going to see nonverbal conduct in an audio tape. Body language, physical reaction to a question, the same thing. These being only audio tapes, they won't reveal that. And there are further arguments about Rule 17A2 in my papers. With respect to privilege, as far back as 1971, the Supreme Judicial Court said that a court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses, including by too broad of subpoenas.
Thank you.
And that was
I guess I have to. The new thing is now, I had someone in my comments like angry at me. I'm supposed to stop the video when I'm going to talk, so I'm going to try to do that now, so I don't make that one person angry anymore. So we're going to stop the video and then I'm going to talk. $5 from Tay. So I just want to show support. Bang, bang. Thank you. I appreciate it. All right, let's keep playing on here. I'm not going to stand up. Jen for Karen Read. Thank you. New YouTube member. I will add $5 to the total. It was not Brazilian girl and she's gone. I don't like when people tell me how to run my show. Don't tell me how to run my show. I'll run my show the way I want to run my show. Okay. What was fun? You know, I got to kind of rant here for a second. Let me let my hair down. I don't have any hair. I don't really care. I'm bald as fuck. I don't care. I always love that one too. You wear a hat because you're bald. I don't care. It's only hair. It's only hair. And dudes that are losing their hair and try to continuously hold on to it, shave your head, bro. It'll just look so much better. But anyway, I have a rant. I don't understand this, and I don't get this, and maybe people can square this up for me tonight. Why is it when it's like 90 plus degrees out, you have these idiots that go out and run? They run, and then they have a heart attack, and they die, and they go, I want to know why that happened. Because you're running in 90 plus heat. What is that proving to anybody? I literally watched, driving over here today, there were two guys running. One guy could barely keep up. He had to keep stopping. Dude, it's 93 degrees out. Why are you running? What are you trying to prove at this point? Oh, why? Because you're going to sweat. You're going to sweat. I'm going to sweat. I'm going to get a good sweat on. I'm going to sweat. You're a moron. You're a moron. Then your body shuts down and you have a heart attack or you have a health emergency and you go, I want to know why that happened. Because you're running in the heat, moron. Anyway, let's go. I don't know why I had to say that. I just did. I think I missed some chats. Let me look back up. Lady Law, $5 says, I have to keep it professional. Let's talk F-Lod. Come on. Come on, buddy. Come on, buddy. I don't get that. Why do people go out and run in the heat? You're not proving anything. All right, let's.
In Reed Pappas case, 358 Mass 613, of the case that ultimately, when it went to the Supreme Court, became Brandsburg v. Hayes. Now, before the court has discretion to prevent excessive or unnecessary interference with the legitimate interests of witnesses by two broad subpoenas. That's stated in Pappas. And the court may take into account all pertinent circumstances affecting the propriety, purposes, and scope of the inquiry and the pertinence of the probable testimony of the particular witness. And in particular, the Pappas court said it may be argued that use of newsmen as witnesses is likely to result in unnecessary or burdensome or gratuitous use of their work product, where the testimony of police or other witnesses would suffice. This, if shown, a presiding judge may consider in his or her discretion. Underscoring that point, when the U.S. Supreme Court affirmed Pappas, it did so, quote, subject, of course, to the supervision of the presiding judge as to the propriety, purposes, and scope of the grand jury inquiry and the pertinence of the probable testimony. In fact, in Brandsburg v. Hayes, the Supreme Court made a majority opinion, but it depended on the concurring, to make a majority, it depended on the concurring opinion of Justice Powell, who wrote, if the news person is called upon to give information bearing only a remote and tenuous relationship to the subject of the investigation, or if the news person has some other reason to believe that his testimony implicates confidential relationships without a legitimate need, he will have access to the court on a motion to quash, and an appropriate protective order may be issued.
All right, let me just get to this reality check. A $2 super chat. Thank you. $2 says, I'll tell you how to run your show like you want to. Thank you. That's funny. Pierre, thank you so much. $5 says you can stop the video or not. Free speech is under attack and the government has been weaponized. Free Karen Read. Absolutely. Absolutely. So the guy that is talking is a lawyer for Boston Magazine. This is the controversy about Gretchen Voss and a conversation that Karen Read had on the record and off the record. And it was about some notes and some conversations that the Commonwealth wanted in the trial. All right, let's keep playing here.
There is no law that subjects the editorial process to private or official examination merely to satisfy curiosity or to serve some general end, such as the public interest. Now, since then, as the case law has developed, in 1980, in the case, in the matter of Walter F. Roach, the Supreme Judicial Court stated that a judge is obliged to consider the effect of compelled disclosure on values that underlie the First Amendment and Article 16 when considering a request to compel information from a reporter or a news organization. They went on in 1991 in the matter of the matter of John Doe grand jury investigation to say that this balancing requires balancing between A, the public interest in having every person's evidence against B, the public interest in the free flow of information, which can be implicated by needless disclosure of sources or confidential information. In that case, Doe affirmed an order quashing a grand jury subpoena issued to a news reporter in a murder investigation where the information sought had, quote, according to the court, low likelihood of benefit to the grand jury when balanced against the public interest in the dissemination of information. That's Commonwealth against Doe, 410 Mass at 602. There's also the Commonwealth against Bowie case from 1995, affirming a trial court order quashing a subpoena issued to a reporter by defense counsel in a murder case. And those two cases, I'd say, are exactly on point. Now, here, Ms. Voss has to some extent performed her own balancing test. And after considerable discussion and consideration, she decided to waive her privilege as to the two recorded on-the-record interviews that took place where the lawyers were present, except for those sections that were lawyer colloquy or designated to be off the record. But she asserts the privilege firmly against production of the handwritten notes of an unrecorded, off-the-record interview outside the presence of counsel. I'd submit, Your Honor, that her notes of that third interview are unnecessary. She's not an eyewitness to any events in the case. She's provided a detailed article that provides a roadmap to Ms. Reed's statements and is set out in her affidavit. Production under these circumstances really does threaten legitimate interests. Some of those set out in the affidavit of Chris Vogel, the editor of Boston Magazine. Judicial intrusion into the news gathering process, the disadvantage of a journalist appearing to be a research tool of the government, the disincentive to the media to save notes and to interview outtakes if such can be casually compelled, and the burden on journalists' time and resources. And my client would attest to you that already the burden on time and money has been more than they care to bear, although they do understand that under normal circumstances, the Commonwealth is entitled to evidence when there are proper circumstances. All of these interests, along with the harassment campaign against the reporter, disincentivize the media from engaging in objective investigative reporting. So there's a principle that is at issue here, and it's the ability of the press to continue to perform their constitutionally recognized role as the fourth estate. Now, there's a additional argument on this, which is recently revised federal criminal guidance that supports the denial of the Commonwealth's request for the off-the-record interview notes or for any unpublished material. The petition for the promulgation of rules, 395 Mass at 172 in 1985, the Supreme Judicial Court said, in cases like this one, where the reporter has no personal knowledge of the events about which he is called to disclose information, it may be appropriate for the trial judge to consider the guidelines of the United States Department of Justice contained in the CFR. And the rule, as revised in 2002 from the Department of Justice, declares that, quote, the use of compulsory legal process to seek information from or records of non-consenting members of the news media constitutes an extraordinary means, not a standard investigatory practice. And it goes on to say that the department may not use compulsory process to obtain information from or records of a member of the news media, period. Now, I'm not saying that that is binding on this court, but it is, I think, persuasive from the nation's federal police authorities. So
let me just pause this real quick. Miss Adventurous Book Mouse, $5, says this is exactly what TB's going through because the Commonwealth just doesn't get it. You are right.
In conclusion, I ask that the court deny the Commonwealth's request as it pertains to the handwritten notes of the off-the-record interview and as it applies to the lawyer colloquy or off-the-record statements in the two audio-recorded interviews. Voss and Boston Magazine do not oppose if the court exercises its discretion to allow the remainder of those two taped interviews to come in, since lawyers were present and on the record. And as to the texts and the emails, if any, voicemails, I'm sorry, those being also under a promise of confidentiality, we would ask to withhold.
All right. So is Ms. Voss willing to still provide the 4-hour interview and the 2-hour interview that are on the record? She's still willing to provide those?
Willing to provide the recordings, yes.
Okay, and how long will it take for you to provide those to us?
Well, there will be some redaction needed. I'm not quite sure how that gets conducted,
okay.
But within 2 weeks,
okay,
possibly less if necessary.
All right. All right, I'll hear the Commonwealth and then I'll give you a chance to be heard again, sir, if you want.
Thank you.
All right, Mr. Lally.
Thank you, Your Honor. Your Honor, the nature or the chilling effect on news gathering that counsel alludes to in the motion in opposition as well as in argument, the Commonwealth would submit is speculative at best. I refer to the court to the decisions that are cited by counsel in the opposition as well as sort of ancillary to those, the Brandsburg and the Jennings. decisions as well. They're federal cases. But essentially what they state is that the state's interest in criminal prosecutions outweighs First Amendment concerns regarding confidentiality, particularly whereas here, the source itself is not confidential. So we're not talking.
Let me just pause this. Cat Randall's $10. Can you theorize why there's all of the coughing in the courtroom? Well, it is January. It's cold. People have colds. Or they're tipping the lawyers. It's a conspiracy. What do you think it is? Colds or conspiracy? I don't know. It's probably it was January. It was cold. People probably have colds. All right, let's keep playing. Thanks for the $10.
Talking about a confidential source, talking about potentially confidential information, but notably what's cited to our federal cases because there is no reporter privilege in the Commonwealth of Massachusetts. It doesn't exist. What I would submit based on the Commonwealth's motion and submissions that there's not even a hint or a scintilla of a hint of bad faith or harassment by the Commonwealth, nor is this a fishing expedition to cull through a vast array of irrelevant information. What we're looking for is statements of the defendant. Not asking for statements of the defendant's attorneys or anyone else. Not asking for the reporter's impressions or thoughts or any other things that may be contained within her notes. The statements by the defendant to this person are relevant, they're admissible, and the Commonwealth's request is specifically tailored to just those statements. The timing of the statements the Commonwealth would submit is also instructive and salient in this sense, in that we're not talking about some sort of vacuum where there's the potential future prospect of a criminal prosecution. These are statements that are made while there is an active criminal prosecution ongoing. The defendant is obviously aware of that. For 2 of these 3 interviews, she's present with her attorneys, who presumably know that there is no reporter privilege in the Commonwealth of Massachusetts. And yet she makes these statements voluntarily. She agrees to these interviews voluntarily. She's not compelled in any way to do these interviews. But the fact that these interviews exist and the fact that there are statements by the defendant that specifically pertain to this case makes them relevant, makes them admissible. And that is why the Commonwealth is specifically requesting those particular items. As far as these other items for which the record holder has an opposition, the Commonwealth has no issue with the record holder properly redacting or vetting through the content to ensure that the only thing that is provided is what the Commonwealth is seeking, which is just statements of the defendant. Nor does the Commonwealth have any issue with any sort of in-camera review by the court as far as deeming whether or not any of those statements as provided are relevant. But the Commonwealth is entitled to these, has met its burden under Rule 17, would ask that the motion be allowed.
So in the balancing test that the law says I have to do, shouldn't I consider the danger or personal risk to Ms. Voss, considering what's already occurred to her?
So, and I'm not in any way trying to minimize that, and I would submit that yes, I think that is something that the court needs to consider in its balancing test. However, I think what the case law also says is that those types of concerns yield to a criminal prosecution in this case.
Here's the whole thing I don't understand about this. Listen, in some capacity, if you're a reporter, you're going to get people that give you backlash. I mean, and the funny thing is, this is what I think is kind of hilarious about all of this. You know, Gretchen Voss saying that she was being attacked, all this stuff. Didn't we hear this before? Who was the reporter? DePietro. DePietro put out there in the public, which is completely untrue. During the trial, he made a tweet that said that Free Karen Read supporters followed jurors home and harassed them. That is false. That is false. And I'll tell you right now, if that even happened, if even an inkling of truth in that even happened, that would have been all over the national news. There wasn't one news story around here that even said that. The mainstream media would have been salivating to have that report. That didn't even happen. So, I mean, the thing is, you have to understand. I sounded like David Yannetti there. My voice went up and cracked. It's like, in these types of cases, there are two sides. You know, one that's going to stay on this side, one that's going to stay on that side. Listen, I get shit all the time too. I mean, people call me out and say a bunch of bad shit to me. I've lost friends over this case. Like, people that I've been acquainted with for a long time, gone. Can't stand me now because of the position that I took in Karen's case. But I mean, if you're gonna be out there in a public reporter and I mean, you're gonna get some kind of scrutiny for the articles or the material that you put out. It's just the nature of the game. If you don't have a spine for it, and you're a jellyfish, you need to get out. Because frankly, myself, I don't give a fuck what people say about me. I mean, I've got past that years ago. I mean, whatever. I mean, this is my opinion. That's why I do this platform. But if you're going to be a spineless jellyfish, then, you know, and that's why I admire like TB so much. He doesn't give a fuck what people say about him. Doesn't care. Just keeps on. Just keeps on. Let's see. Let me go back up. I think I just saw a chat come through. Did I see a chat come through? Nope, I thought I did. Okay. Actually, you know what? I did see something come through. Hang on. Let me just read this while we have a pause. I got Krista, thank you so much for the $10. This is back to the back to the running. And you mentioned you will only ever catch me running, being chased by the McAlberts or the McCabe's. All right. Thanks for the 10. Let's add it to the total. We're so close to the 50. All right. Let's keep playing here.
Case. And in part, again, just based on the limited specific scope of what the Commonwealth is requesting, again, I understand Ms. Voss's concerns when it may come to her notations as they apply to her impressions or her thoughts or things that she observed or whatever the case might be as to whatever her notes contain. But the only thing that the Commonwealth is seeking from those notes is statements by the defendant. That's it. So as far as any other things that may be contained within her notes, Commonwealth's not interested in those, not seeking those, not asking the court to order those in any way, shape, or form. And again, as it pertains to any of those items, the Commonwealth would suggest that in this case, I think an in-camera review by the court would be appropriate based on whatever is submitted.
Real quick, $25 just came over on PayPal. Elaine, thank you so much for the 25. We'll add that to the total. I appreciate that. All right, let's keep going.
As it pertains to that, sir, I don't think there's as much of a concern, and there's no real objection that I can surmise as to the first two recorded interviews. But as it pertains to the notes, I think an in-camera review would be appropriate.
What do you say about that, Mr. Bergeron?
A couple of things, Your Honor, very briefly.
Sure.
I'm not sure that the Commonwealth heard what I said because Ms. Voss does not oppose the release of the two interviews, save the off-the-record portions of the lawyer.
I think he's talking about the third interview.
Yes, but I'd also refer to any part of the first two interviews deemed off the record that would contain any statements by the defendant. So I don't know what the off-the-record portions contain, but if they contain statements by the defendant, the Commonwealth would be seeking those as well.
Well, that gets to the next point, really, the distinction between confidential sources and confidential information. And I'd submit that that's a distinction without a difference. The same.
But is there any case law that supports that?
I don't have it at the top of my head, Your Honor, but I do believe.
Please feel free to provide it.
All right.
Interrupting.
Finally, I want to make clear the Boston Magazine and Ms. Voss are not arguing that the Commonwealth is acting in bad faith. In fact, I appreciate the way in which they narrowly put their subpoena in terms of only wanting statements of Ms. Reed and not of anyone else, not from counsel and not from other things. I do take issue with the notion that the Massachusetts law doesn't recognize the common law privilege. They do. They recognize an evolving privilege that's really flexible enough to take in the particular facts of every case. And the cases are uniform in saying that the judge has a duty in the civil side to enforce Rule 26C with particular rigor, and on the criminal side as well. The question of harassment comes up as part of that test. And it's true. We're not saying that the Commonwealth has harassed Ms. Voss, but she has, in the unique circumstances of this case, suffered and will continue to suffer harassment to the extent that her role becomes large. And ultimately, Your Honor, there's a lot there, and we're not saying the Commonwealth is overreaching, and we're not saying that the Commonwealth is in bad faith, but we are saying that the Commonwealth is asking for too much.
Okay. Thank you very much. So you say it'll take you 2 weeks to get those first two redacted and sent in.
Thank you very much.
And if you want to respond with at least that case, so I'll take 2 weeks then to decide this. So the sooner you can get me anything else you want to get me. I am concerned about the safety of the reporter. She shouldn't have to suffer harassment or any danger as a result of this.
It's funny. She's concerned about Gretchen Voss, but not concerned about all the harassment that Turtle Boy gets and the threat to Turtle Boy. It's funny how that works, huh? Funny how that all works. No one's concerned about him being harassed. No one's concerned about his well-being. It's funny. All these judges are not concerned at all. But, oh, boy, that Boston Magazine reporter, we got to, that's the concern here. Right?
Of course not, Your Honor.
All right.
Counsel, is February 1st, which is 2 weeks from today, is that doable?
That's doable.
Okay. All right. Thank you. So, Ms. Giannetti, we need to get a date for the remaining two motions that were filed by the defendant, the motion to dismiss and the motion.
She doesn't care.
To disqualify the district attorney's office and sanctions. All right. So as you probably know, we're in the middle of a trial that's going to go a few weeks. Jim, can you suggest a date?
Jim.
I can. How about?
May I interject, Your Honor?
Oh,
with regard to
Yannetti.
a date? I know that our
All right, here we go. Bridget, is Monday going to be televised, and will you be streaming it for us and recapping it? We need your opinion that day. So my plan is I will be down at the courthouse that morning or afternoon. I thought it was a 2 o'clock hearing, but I'm now hearing it's a 9 o'clock. Maybe some of the people in here can get me a little updated because it's changed multiple times from what I'm hearing. Maybe Scott knows in the chat. But my plan is this. I'm pretty sure it's going to be televised. This is a pretty hot case around here, and now it's caught national. And 9 and 2 or 9-2? I don't understand that. 9 a.m. or 9 to 2 p.m. I heard 2. Yeah, I'm very confused about it. It'll get. So anyway, I'm sure it's going to be televised. It's 9 a.m. Okay. So I will be there at the courthouse. I probably will stream outside the courthouse for about an hour. And then once court starts, I like to at least hear what's going on down on the ground. I will get video because what happens is after 9 o'clock, the streaming service around the courthouse absolutely sucks. And when you stream, it just becomes garbled, gooey. I don't even know if that's a word. So what I'll do is I just usually collect video and I'll upload everything when I get back. And that night we can go back and recap. I'll do a recap that night. So it's probably going to be a ton of people down there, I assume. I plan on getting down there early. I do not have Starlink, but if anybody wants to hook me up with it, Starlink, you could sponsor me, Elon Musk. but I'll probably just do my nightly recap. And I know Jess Machado's been super busy, but I'm assuming that she's going to be down there as well. And maybe I can try to get her on that night and we can do a full recap together. If not, maybe Mazza, if he heads down there, we can do a recap together. So that's my plan. All right, let's finish this up. And then I got a little bonus feature here that we'll play through.
Final pretrial is February 15. Our request will be
February 15th? I thought it was February 26th.
We have two.
Okay.
We have February 15th and February 26th.
Okay.
So you're both
Where
right.
are we at?
Well, that actually fits in with what I was going to ask, because
Thanks,
our
Scott. I heard
request
2 p.m. as well.
would be for the motion to dismiss and the motion for sanctions to be heard on February 15. I'll tell you why, Your Honor. One thing that I did not mention regarding the conference call that we had yesterday with the U.S. Attorney is that they notified both parties that they'll be going through the TUI process to take the extraordinary step of releasing information from their investigation to the parties in this case that directly bears on our case. This is almost unheard of. There's an active investigation, and they're going to release information to both parties because in good conscience, they can't allow this case to go to trial.
Did they give you a date, Ms. Giannetti?
Getting on the record
They
yet.
did not, but they did say that it could take a week or two, I believe, to go through the TUI process. My expectation is we'd probably get this information sometime in early February. And I don't want to argue, particularly the motion for sanctions, without seeing the evidence that's out there, because I believe that evidence will impact our argument.
All right. Does that date work for the Commonwealth for that purpose?
John, thank you. $5. Aussie, thanks for checking in. Says the feds are going to drop stuff. This case will be dismissed before it gets retried. I think, in my opinion, that they're going to keep pushing and pushing and pushing, and then they're not going to get anywhere. And I was, kind of joking around about this, and this is the best case scenario, on some holiday weekend, probably Labor Day here in Massachusetts, which would be in September, like a Friday. This would be secretly dismissed. That's the best case scenario. But I've heard that conversation, but I don't know. They're just going to keep pushing this, and it's stupid. It's absolutely waste of time and resources. And, Karen needs us more than anybody right now, to keep raising money for her defense fund. She needs a lot of money for her defense fund because she might have to go through this all again. And it's exhausting and it's tiring. And hopefully something gets done here soon. But I don't know. Where are the feds? Where are the feds? We've been waiting. So we'll have to see. But the best thing that you can do is just keep donating. I'll do my fair share here and keep cutting back the 25% to help her out. If you don't want to do that, you just go right to her defense fund link, or you can participate when they start doing the popcorn sales or raffles or anything like that. But, we appreciate it. I know the family appreciates it. I've had conversations with Karen's mom down at the courthouse, and she says, I always like to wake up the morning that in the mornings or the mornings before court. And I always go to the website, the donation website, and she'll say, I'll see little LTL up there. And we appreciate all the money that you've been raising. So, and they appreciate everybody. They really do. And there was a really remarkable thing that happened over the last couple of days where $50,000 was raised through popcorn sales. And then the percentages of all that got kind of divided out. So it's all good stuff. All right, let's finish this up. And then I got a little bonus feature here to play through.
I'm sorry, the 15th?
Yes.
That should be fine.
Jim, is that at 2:00?
It is
Appreciate that. Thank you.
at 9 o'clock.
Excuse me.
All right. Assuming we're not on trial, it'll be at 9 o'clock. If we're still on trial, it will be at 2.
That's fine.
Your Honor, the only issue there is that I do have a trial before Your Honor that's scheduled for February 13th. So,
Right. That's the case that I expect we'll be on trial for. And if that's the case, we have to finish that. We've got a very busy trial schedule. So if we're on trial, we'll see you at 2 o'clock. All right. So stay in touch with Mr. McDermott.
Oh,
All right,
yeah.
is that it for today then?
That's it for the Commonwealth. Thank you, Your Honor.
You all set, Mr. Yannetti?
Yes, Your Honor, thank you.
Okay. All right, and Mr. Birchie, I appreciate you being here, sir. All right, hearing's over. Jim?
Thank you. February 15th.
Okay.
That's it. Okay. So I have a little bonus feature. I'm going to ask the room to gauge the temperature in the room here if you want me to play it or not. Since I got a apology from Vinnie Politan, not well, actually Vinnie Politan's producer. So I'll take that as an apology. I'd like an apology. It'd be great if I got an apology because I haven't heard anything after my email. But we'll do this. I have a segment that I love playing because Melanie Little schooled. This is back on January 8th, 2024. It's about a 20-minute segment. And it was when Melanie Little and Jennifer Coffindaffer were on the same panel together. They were arguing back and forth the evidence in this case. I will leave it up to you all. Do you want to watch that? We can do a little bonus feature here. If you do, hit a 1. If you don't, hit a 2. And I'll end this live and go home. So let me know. Give me a 1 or a 2, and we'll vote through that. All right, I'm getting a lot of yeses. Okay, a lot of 1s. Perfect. All right, we will play this. Okay, I think we made our point. We made our point. I love the 1s. Good stuff. I haven't seen 1, 2. All right, let's watch Melanie Little school Jennifer Coffindaffer on Court TV. We'll play this little segment and sit back, have some laughs, and enjoy a little bit. So.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road.
Hear about that, Meatball?
In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie.
That's the Norfolk County DA, the one who's in charge of the prosecution of Karen Reed. A public video that was released, very unusual. But again, this is a very unusual case in what's been happening. And there's been this groundswell up there in Canton and in the area. And there's been fingers pointed at people, including this trooper.
Crystal, what I would do is just follow me on Twitter. I tweeted about it today. I talked about it earlier in the show. If you have Twitter, or you can go to my Twitter account and just read. There's my tag for Twitter. You can just click on there, and the link should come up for Twitter. There you go. You can follow me there. Let me just get to do this. Mod Squad, $10 Canadian. Thank you for replaying these hearings. Also, in defense of the girl from yesterday, some have sensory overload when too many people are talking at once. Don't take it personally. Well, listen, I'm live. I'm loud. It's how I do it here on my show. So I don't know. I would just say maybe if you can't handle it, sit that one out. But I appreciate the $10. Appreciate you being a subscriber here on LTL. Okay, let's go.
Proctor, and you heard the DA say, listen, he didn't plant evidence. He wasn't even there, and he's not connected to anyone that was in the house or any of the parties involved here. Well, the defense is saying something completely different. But let's begin by taking a look at the Commonwealth's statement of the case. Okay, so this is from the prosecution side. They say, in this, Trooper Michael Proctor and Sergeant Yuri Buchanek were among the troopers whom responded to the scene and began interviewing witnesses. So this trooper, very important part of the defense case, according to the Commonwealth's statement of the case, was there. Then today in court, Alan Jackson went a little further, to outline evidence that he believes shows that Trooper Proctor's and his family is connected to the parties involved here. Take a listen.
We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor and these third-party culprits that have been implicated in this case that we've brought to the court's attention, the Alberts and the McCabe's. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, with a person by the name of Colin Albert, pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie, it's a photograph. And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together, they're in a wedding together, in the wedding party. There's a third photograph.
And when was that? When was that? When was that? 2012.
So this relationship, as the court just noted, and I was about to get to in a second, is not just days old, months old, weeks old. This relationship is decades old between these families. There's another photograph that the court has seen, Trooper Proctor literally on the dance floor with Colin Albert. Trooper Proctor was seated at the same table having dinner with Colin Albert, Chris Albert, and Chris Albert's wife. But I would highlight the last point that I think should be highlighted for the court's attention, and that's the Facebook post. Trooper Proctor's mother refers to the Albert family as the Proctor's second family. So one might actually ask Mr. Morrissey, who's actually lying in this case?
Okay, so now let's take a look at this visual because he's throwing a lot of names out there and it's a little confusing. So I want to make it a little less confusing. So the Proctors are that's the trooper, but what is his connection to the Alberts and the McCabe's, et cetera? But who are these people? So this is the house where John O'Keefe was found dead on the lawn, okay? The owners of the house are Brian Albert and Nicole Albert. They are married. Now, Brian Albert has a brother named Chris who's married to Julie. They have a son named Colin. So Colin is an important name in all of this. Chris, Julie, again, brother of Brian Albert. Brian Albert and Nicole, they have children, Caitlin Albert, Brian Albert Jr., and then there's a friend of theirs, Julie Nagel. Then you look at Nicole Albert, her sister, another important name in all of this, Jennifer McCabe. Jennifer McCabe, who's married to Matt McCabe. So this is the house. So the night that John O'Keefe got out of the car in front of the house and either went to the party or was murdered or run over by Karen Reed, who was in the house? Take a look. This is what's alleged here. Brian Albert's there. Nicole is there. Chris and Julie are not there, but their son, Colin, is there, which is Brian's nephew. Their kids are there. Brian Albert Jr., Caitlin, and their friend Julie. Also there, very significant, is Jennifer McCabe and Matt McCabe. All of this, trying to understand the names, the relationships, and does it all lead to some conspiracy, bias, framing, planning evidence? Let's bring in our guests. Joining us in New York City, attorney, podcaster, Melanie Little is with us. In Boston, Massachusetts, criminal defense attorney and author of the books Super Predators and Law and the Tough on Crime Myth, Peter Ellikin is with us. And down in beautiful Jacksonville, Florida, retired FBI Special Agent Jennifer Koffendorfer. Great to have everyone here. All right, Melanie, I'll begin with you. So is the defense really predicated on the fact that Trooper Proctor, who was at a wedding and his family is close with the Alberts, is literally planting evidence to literally frame Karen Reed for murder? Is that what the defense is saying here, Melanie?
I think that's exactly what they're saying. And they're also saying that there are a lot of questions of fact here. You know, if Trooper Proctor, who was the lead investigator.
I hate to interrupt you. I just want to preface our entire conversation tonight. I'm not concerned about reasonable doubt, okay? Reasonable doubt, I want to know about the truth tonight, because the defense is saying John O'Keefe was murdered by people in that house.
Fired up.
And the prosecution saying he was murdered by Karen Reed. So I want to look at these as two cases and evaluate what's going on here. Let's begin with the defense case. So Melanie, go ahead. I'm sorry I interrupted you. But I understand this is a case that's going to be tough with reasonable doubt. But I want to get to the truth tonight. So what do you see in terms of these relationships? Is that enough? Like someone would do
Let her
this?
speak, damn it.
Frame this woman?
Well, I can't see why anybody would find it so beyond the pale that it could never actually happen. I mean, if it is true that Michael Proctor, who's the lead investigator on this case, has close ties to the Albert family and to the McCabe family, everyone inside that house was a relative except for one person. So if the defense can show that there are close second family type ties between everyone in that house and the lead investigator on this case, that could be something that definitely could lead to reasonable doubt. I know you don't want to go there, but
yeah,
that's exactly
again, I'm not concerned about the reasonable doubt tonight. Not tonight. When we get to the trial, I'll get to it. I'm trying to figure out the truth here, Peter, because I've got Alan Jackson, a former prosecutor who was amazing out in California, jumping up and down literally on the courtroom steps, telling us that the prosecution has it all wrong. The DA has this all wrong, and that it's the police who are responsible here.
Well, yeah, first of all, I'd say that there was such a conflict of interest here. Even the appearance of bias, I don't know why Trooper Proctor was in charge of this investigation. There's just too many ties we saw. That
Well, the defense is saying he's in charge because he's framing Karen Reed. That's why. He's not going to give up the lead on this because he's got to save, his friend and his friend's son and whoever else they're going to allege did this and frame somebody for this.
Yeah, and I guess that's, I think we've all been seeing enough cases over the years that it's not absolutely beyond the pale that some police officer may not be truthful. So,
wait, there's a difference though. This is a different. This segment's kind of annoying. I forgot how kind of annoying this is. I mean, Vinny hasn't let any of his guests talk. He keeps cutting them off. Anyway, I just want to watch Melanie's school coffee daffy.
Difference between not being truthful, forgetting something, and literally taking evidence and putting it somewhere so you can frame someone for murder, take away their liberty, and put them in jail for the rest of their life. This is different than just making a mistake.
Do that to protect a friend, though, or your long-term friends with the family. We saw it goes way, way back, and his mother is saying that the Alberts are a second family to her, and we have one of the family members, Jennifer McCabe, going to his house. Who goes to a state trooper's personal home to go chat with them, and it's not even reported in any paperwork. So with those kinds of biased ties, would there be a motive? Could anybody do that to protect their friends, to protect people you've known for years? And that's why when the DA here has said that it's a lie if you see any connection between him and the family, the facts just don't bear that out.
Yeah, that was baffling. And I'm glad you mentioned that. Let's take a listen to Alan Jackson today talking about that meeting on September 25th of last year.
On September 25th, 2023, that one of those family members, Jennifer McCabe, was the subject of great interest in this case and a primary person of interest in this case, is invited to Trooper Proctor's personal home for some sort of off-the-books meeting. They've now admitted that Jennifer McCabe, a central character in the middle of this investigation, in the middle of this crime, was secretly meeting and or socializing with the lead investigator and or his wife in the living room of their home. And that, Your Honor, is a problem.
Okay, Jennifer, let me ask you, should we be concerned, when I say we, the public, that the DA comes out and says there's no relationship with the family here, Proctor had nothing to do with what was going on that day, and it seems that that's not necessarily true, and then McCabe going to Proctor's house? I mean, should there be some concern here?
I think it's very important to truly understand the relationship. Brian Albert, who lived in the house where this incident occurred out in the front, his brother's wife's sister was friends with Proctor's sister. Okay, that's how far removed. I just hope your audience, the
One more
attorneys that
time,
are
one more
present
time, one more time.
Puts her through it again.
We'll do it
Brian
together.
brother's wife's sister was friends with Proctor's sister. Okay, that's how far removed. In other words, I could tell you, I have no idea who my sister-in-law's sister's friends are. I mean, there's no way. I couldn't tell you one of them. I don't even know my sister-in-law's friends. And we're
That's
very
because you have no friends. That's because you have no friends. You don't even know who your sister-in-law's friends are? What? That means that you don't socialize. You don't get out and socialize, Coffee.
very close. So my point is, this is how far removed it is. And then it's, again, Proctor's sister. Detective Proctor, I'm sorry, Trooper Proctor and Brian Albert, the home again, they had never even met each other. The pictures you're showing are his brother's family, his brother's family. And again, that's through this, removed relationship. So I think it's very important to understand that just because you have a Proctor there and an Albert there, they're not the same family unit. Second of all, everybody's forgetting about Brian Higgins. That chart, you're missing the ATF agent that was there. And that's very important too. So to have this conspiracy work, we have to have a Boston police officer, Canton Police, EMS, an ATF agent, the medical examiner's office, the district attorney, and the state police all combined to do this huge conspiracy against who? Nothing against Karen Read, but who is Karen Read? Karen Read is no one special other than she was dating in a relationship that was falling apart the victim deceased.
Okay, everyone stay where you are. We've got to hit a quick break. We've got to hit a quick break. When we come back, much, much more. Don't go anywhere.
Coming soon to Court TV.
These murders have shaken our community.
Why did you do it?
The doomsday prophet, Chad Daybell.
Prosecutor Gary just today.
Oh, I remember that. Hey, there's me. Look at that. I remember that hearing. That was a cold friggin' day, man. That was a cold day. Super, super cold day. Super, super cold day. Super cold day. I remember that. All right, let's go.
Free Karen Read! Free Karen Read! Free Karen Read! Free Karen Read! Free Karen Read!
I made the thumbnail.
All right, folks, there's the scene. Like I said, you don't see this. You just don't see this. So Matt Johnson, as we saw, has been up there this week. So he went to the neighborhood and is going to walk you through the story again. It's a very complicated story. And again, there's actually two stories we're talking about at the same time. What the prosecution says happened, what the defense says happened. Take a look.
We're here in Canton, Massachusetts. This is just outside of Boston. And on January 28, 2022, Karen Read and John O'Keefe went out drinking. They went drinking here at the Waterfall Bar and Grill. Later that night, they decided to meet up with a couple of friends that were at a bar down the street. It's about a block away now, and they make their way over here to CF McCarthy's Bar and Grill, and they meet up with Jennifer and Matthew McCabe. Around midnight, the bars begin to close, so everybody is invited back to Jennifer's sister's house, which, according to GPS, is about an 8-minute drive. Let's go check it out.
Oh, the music.
They eventually make their way here to Fairview Road in Canton and at this house. This house was owned by Brian and Nicole Albert. At the time, Brian was a good friend of theirs and also a police officer. Now, what happens next is what this case is all about. Prosecutors say that the couple actually got into a fight, and when O'Keefe exited the car, Karen Reed backed over him, leaving him to die in the curb here in front of this house during the snowstorm. Police collected a lot of evidence at the scene, including what appeared to be a broken cocktail glass.
Remember, he did a pirouette. Remember, he did a pirouette. The curb, well, it was like, according to the Commonwealth, it was 30 feet away from the curb.
With blood around it, and also a broken taillight. Now, Reed says when she pulled up to the house here, she wanted to know if the couple was really invited. It was late at night. So she watched John O'Keefe walk up to the front door over there. And when he didn't return to the car and didn't return her phone call, that's when she said she went to his house and fell asleep. The next morning, Karen Reed hasn't heard from John. So she starts making phone calls. And then she comes back here to the last place she says that she saw him, over at this house on Fairview. And that's when he's discovered, lying in the snow dead. Now, Reed's defense says a very different story. They say that John was actually beaten up in the basement of this house and attacked by the family dog. They claim that he was dragged outside and left in the snow to die. Now, being here on Fairview Road in Canton, a few things come to mind. Why didn't someone see anything? Because the neighborhood, it's fairly dense. The houses are close together.
Because they
But you have to
doctored
keep
the
in mind
cameras.
that this happened in
Yeah,
January,
footage.
in the middle of the night, and it was also a snowstorm, whiteout conditions. Now, another key for the defense is the snowplow driver who said that he cleared Fairview Road here the morning that John O'Keefe was found dead. He claims that he didn't see a body in the road or near the road.
Okay, all my guests back with us, Melanie Little, Peter Ellikin, and Jennifer Koffendorfer. Melanie, which case is easier to prove? That he was murdered in the house or that he was murdered by Karen Reed?
I have so many questions. I think it's easier to prove that he was murdered in the house.
Tell me
in my
why.
opinion. I mean, where's the
You're
dog?
Koffendorfer.
Where's the dog? I saw the photos of John Proctor's right arm that were taken at his autopsy. They have what clearly looks to me to be like animal scratches on them. All of a sudden, the family dog of 7 years, they had a German Shepherd in the house. The family dog is gone. They rehomed the dog. The dog is missing. The dog's DNA cannot be tested to see if those were, in fact, animal scratches. You know, there's a cocktail glass allegedly on the lawn. They never searched the inside of the house. Why did they never go inside the house to see if they had those type of glasses inside the house? Why was the basement flooring ripped up? The house was sold. Why did this police officer who owned the house and his wife never come out of their house to look at the scene when there is a dead police officer on their lawn? I have so many questions. And I think at the end of the day, the jury is going to have to decide the facts. And if we have so many questions from looking at these facts, I think a jury is going to have a lot of questions too.
Jennifer, which case is easier to prove?
Oh, without a doubt, the case that he was hit by Karen Reed. She had the motive. These are not dog scratches. That has been said by two medical examiners, separate medical examiners that examined him. Also, there were samples sent to a lab in California to test for non-human or canine DNA. Negative. So I find it so interesting that people want to look at a picture and all of a sudden they're medical examiners, they're doctors with PhDs, and they can say these are dog scratches. Second to the point there, the Brian Albert, they sold their house months and months after that.
Oh.
Also, they had a leak downstairs in the basement that resulted in quite a lot of damage, and that's why the flooring was replaced. As far as the dog, Chloe got into a fight with another dog in that neighborhood.
Oh.
And during that fight, one of the neighbors went to separate the two dogs and was scratched or bitten. And it was decided amongst the people that they would go ahead and rehome the dog as opposed to making an even larger deal out of it. So there are very logical explanations, but these are the types of innuendos that have been completely blown up.
That's it. All right. That's it. That's it, everybody. What is the total for tonight? What is the total? Do we get to at least $50? At least $50? What's the total? Let's wait for the total. My head hurts now. I like that. What is the total? 164. All right. 25% of that is, let's see. Get my dopey calculator out because I'm terrible. $41. All right. Not quite 50. I like to get 50, but I'll do this. I'll give the $9 to get to $50. We'll donate that to Karen Reed's Defense Fund tonight, the 25%. So I'll make the donation after the show. You know how I do it. Reality check. Thank you. If there was a leak, why don't what does it say? Why don't they have a plumber's bill? Yeah, that's very good. That's a good question. Sarah and the shock and horror, $36. I think we're gonna get there for the $50 bucks. Let's just get a new total. Let's see where we're at. So we had 160, and we'll do this. Is that a pound? Wow, look at that. Watching from London. Super sticker, $5. $5. Where are we at? 210 total. I think it's going to get there. 25% is going to put us at 52. I'll go to 55. We'll do 55 tonight for Karen's Defense Fund. I appreciate you all. So, like I said at the beginning of the show, little off. My social life has changed a little bit. I'm going to have more time in my schedule right now. So I plan on, you guys are amazing. Look at all this. You guys are so great. John, thank you. $36, Aussie. Appreciate it. Get this to the 50 for Karen's Defense. Thank you. I appreciate that. We're going to probably get a little bit more here. New member. Thank you. $5 added to the total. We'll get that. So, like I was saying, my schedule is pretty much wide open now, my social schedule. So I will be doing more lives and concentrating on some more cases. And, we'll keep up with Karen Reed's case, of course. I said that I won't stop until her name is free and clear. So, $4.99, Laura. Thank you so much. Thank you. I appreciate it. We'll round that up to $5. So that is it, my friends. We're at 256. That's going to probably put us at about probably 55. 256 minus 25%. Oh, 64. We'll go to 65. 65. So yeah, I think that's going to end the show for tonight. I'm going to take tomorrow off. I have a recorded with Collier Landry on Thursday. That's 8 p.m. I may do something on Thursday. Probably come back on Friday because I'm off on Friday, and then obviously the Sunday night show too. So, what was I going to say? Monday I'll be at court. See what happens. So we'll go to $65 tonight for Karen Reed. I don't know. I think that's it. Thank you, everybody. I appreciate you all. Yes, free Karen Reed. I'm just looking at the chat real quick before I close it up. Not good, man. Not good. Thank you, moderators, and thank all the donators. Thanks for all this, the subscribers, new members. You're all amazing. Thank you for supporting the channel. Again, little off. We push on, and I don't know. That's it. All right, everybody. I will talk to everybody. Rogue, thanks for keeping the title. The total. Thank you for keeping the total. We'll get that donation up 65 tonight. All right, everybody. I'm going to take off. Have a great evening. If anybody needs to get in touch with me, I'll give you my email. I get emails all the time. Email address is there. It should come up in the link. Let's Talk Live Podcast at gmail.com. All right. I'm going to go for reals this time. For reals. Good night, everybody. Bye.